Lawrence County depends on WDXE News, on the air since 1951. This is the 1053 WDXE.
And it is time for Stan Pierchoski with Pierchoski Estate Planning and Estate Law. Bulletproof Estate Planning.
Bulletproof Estate
There we go, we got it.
We did.
How are you, buddy?
Good, how are you?
It's been a whole week.
It has been a whole week.
Been a busy week as well. Is your volume like you need it? Sometimes means turns that thing up really high.
It's up a little high, but I'll just stay away from the mic. I can't figure out which cord goes into the hole.
It'll be one of these others. How about that?
Yeah, that's it. Bring it up just a hair more.
Bring it up a
yeah,
little bit.
that's good right there.
All right, there we go.
As long as I'm broadcasting.
There you go. Yeah, you are up and at 'em and ready for a Friday.
I am ready for a Friday. You know, I'm kind of tired this morning. My wife's been out all week, and so I've been kind of. I had the horrible task of taking care of myself, and making something to eat. It's like finding my clothes, and it's like, what's up with that? I miss her. So she'll be back tomorrow night. So she'll be back over the weekend. But she had to go up north for a family.
Oh, okay.
It was a funeral and some other stuff.
Yeah.
But anyway. So if I look disheveled, it's because it's my own doing.
You had no one to take care of you.
I know.
Oh my goodness.
You know, when I got married, we sort of said, you know, I don't cook. I don't like to cook. I mean, I can make a hot dog. I can make the basics, you know, but it's like I just don't like to cook. I stay in my lane. There's certain things I do and I'm good at, and, you know, and I like to do, and I do this. But cooking just never appealed to me much. So, and she said she does, and so, you know, it's a perfectly good understanding. Anything breaks, I'll fix it. If anything's bought, I'll buy it. I'll do this. I'll do that. And you know, but that's your lane, cooking.
Yeah.
And she does a great job of it. So.
Yeah.
But when she's not there, she's certainly missed.
I take it by spells. I don't mind cooking. There's not a lot that I know how to cook, but the things that I do cook, I kind of enjoy it by spells.
You know, I get home, I'm tired, and there's nothing left but the hot dogs we had last night. And it's like I just look at it and say, you know, I want to go watch the news and I just want to chill out for a while.
Yeah.
And I don't want to spend any time making something. You know, I'm hungry enough for it, but it's like I'm just going to heat up a couple of these hot dogs and get through.
You can always, at my place, you might find a bowl of cereal if Daniel hadn't eaten it all.
There you go. But anyway, on to other things. You know, hey, we're here to talk about bulletproof estate planning, like we do every Friday. And just let me start off with first of all, the call-in number, because I remember last time we completely forgot it till the end. So let me just go over that. This is a call-in show if you want to.
That's right.
If you want to ask a question, please do. If you want to share an experience, please do. If you're worried about it being too personal, just you know, make it generic.
Yeah,
we can do that. I can handle the generic circumstances just as well as real life. So, but anyway, if you want to call in, the telephone number is 931, of course, 766-9393. That's 766-9393. Pretty easy to remember.
Yes, indeed.
So, okay, so coming up, seminar on September the 20th. That's about a month out, but it'll be the 15th right now. So yeah, about a month and a week. So that's going to be right here at the WLX back of the building, and we call it Will's Trust in the Nursing Home, and that's what we're going to talk about. It's a Saturday seminar, so we do those at 10 o'clock in the morning. And if you want to get RSVP'd for that, just call my number at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222, and tell us that you're coming and how many are coming. The RSVP is pretty loose. We just like a head count, know who's coming. So it's not too early to sign up because we've already got quite a few. But you know, here at the back of the building, what they call the Country Cafe is a big venue, so we don't worry too much about running out of space. But sometimes if it gets full, I like to have some kind of like PA system that I can use for people that end up being farther back.
Right.
So, yeah, if you're interested in that, I'll bring it up again at the end of the hour. All right, so, you know, maybe we'll get some call-ins today.
I hope. That would be great.
I got a few things, you know, we can talk about. One thing I was talking about yesterday I was talking about this week with a couple of people is one of the things I think is kind of overlooked in estate planning, and that is guardianship. You know, now,
okay.
You know, most of my clientele is senior age, right?
Right.
I mean, most of them. But so you probably don't have minor children at our age, right? But you may have adult children who have minor children, right? And if that's the case, you know, you can if you're listening to this, and you may say, well, that doesn't apply to me. but it might apply to one of your kids, and you might want to relate it to them. Because, you know, when you're young, you don't really think of this stuff. And when you have minor children, I mean, you don't, before you have minor children, you never think of this. But once you have children, let's say, you know, you're in your, somewhere in your mid-30s, later 30s, you got 2 or 3 minor children and a wife. And a thought that can really wake you up in the middle of the night is, what if something happened to me and my wife? You know, we're out on date night. And if something happened to us and we didn't come home, what's going to happen to these minor children? And that's a scary thought.
It is.
Without planning, it's a very scary thought, because I can tell you exactly what's going to happen, and it's not pretty. You know, people will be involved and will take over and take charge of the kids. And now, I'm not giving any opinion on the quality of care that you get when the county gets involved and does that. But whatever it is, I mean, I'm sure they do a good job. But you have these strangers injected in these children's lives with a lot of other stuff going on. They find out mom and dad aren't coming home. They don't understand what's going on with that.
Sure.
Now these strangers come in and they take them, and usually remove them from the home and take them somewhere else. It's a tremendous upheaval in the life of a child. They don't know what's going on. The natural reaction is fear, and it's not a good time for them. And I used to get appointed to this kind of work, and people, I don't know that they ever really get over it. I mean, they certainly will never forget the memory of it.
No.
And so but it's a preventable thing. Now you can appoint and nominate guardians for your minor children.
Right.
And when we do that, we like to give that some thought. Why would we nominate children, guardians for our children? A lot of times people say to me, well, you know, I've talked to the family, and Aunt Gertrude said she'll take care of the kids if anything happens to me. You know, and Aunt Gertrude might end up with them, but that doesn't happen automatically just because you appoint her.
Right.
All guardianship in the state of Tennessee ends up with a court order. Okay, so what we want to do, so you have to go to court. The court's going to decide.
Okay.
But the way
All right.
what's the way to put this? The way we hedge our bet to make sure we get the people we want is like this. We do something called the Children's Protection Plan, where we appoint guardians. And you
Okay.
name the people. You know, if you're a husband and wife, you pretty much say, if something happens to me and my wife is also not available, because if something happens to you and your wife is around,
Right.
the parental rights always are superior to any kind of guardianship.
Okay.
And so the other parent is in charge now. But if the second parent is gone, or you're both gone together in some sort of simultaneous event, then you name somebody. Let's say you name Aunt Gertrude, okay? And you might want to name more than one. Aunt Gertrude,
Sure.
but if she's not available, because
Right.
a lot of people will say, I'll name my parents. That's a pretty good choice, but your parents are older than you, and they may be of somewhat limited time, I don't know.
Right.
But they're not in the same age group as you. And so it's always good to name at least 1 or 2, or possibly 3. And another thing we want to keep in mind is what we call long-term guardian or short-term guardian. Now,
Okay.
around this neck of the woods, often they're one and the same. But they don't. But it could not. It wouldn't have to be that way. Let's suppose.
Right.
Let's suppose I'll use myself. I have a brother, and he has a daughter. If I would name him as a guardian, he lives up in Pittsburgh, Pennsylvania. Okay.
Okay.
That's where he lives and works, and I live here.
Yeah.
And it's like, well, if I name him, he's my long-term guardian. Meaning he's the one that would eventually end up with the children. Him and his wife would raise them and stuff like that.
Sure.
But getting them from here to there there's going to be a lag time to get everything together and transport the children to Pittsburgh, right?
Right. Right.
So we like to appoint short-term guardians because the people that can, kind of like a first responder in a way, somebody that can be there in 30 minutes to an hour and have the authority to take over the children so that they don't have to be taken into some kind of child custody.
Sure. Sure.
And then they are short-term taking care of the children until we can make the final arrangements to send them up to the person that's up in Pittsburgh, stuff like that. So there could be a need for short-term. A lot of times, the short-term is the long-term, which is a little easier.
Yes.
But I mean, you can see the circumstances could call for something else.
Yeah. Absolutely.
And now the reason we do this, is when you get a guardianship, like I said, it always ends up in a court order. And you go to that statute. The statute gives the court certain criteria to weigh. And it's quite a long list of stuff that they look at and put whatever weight the court thinks they want to put on it, and to pick people. And so you go to court, you got 2 or 3 different people saying, I'll watch the kids and I'll watch the kids. The court's got to make a decision, right?
Right.
And the court will evaluate everybody based on this list of criteria that's in the statute that they're supposed to consider. Well, one of the things they're supposed to consider, not only consider, but put a great weight on, and that is if the parents during life, when they're of sound mind and disposing memory, had named people to be the guardians for them during life, and they're supposed to put a great weight on that, and it makes sense. You know,
Sure.
if the people have done that, then they've thought it through, they've thought about it, and they thought, okay, I know this person, and that's the person I want to raise my kids because
Sure.
I have these morals, thoughts, values, and that's kind of what I want. The person shares those morals and values, and they'll raise the children the way I want to. And you know, it's probably safe to assume that they already talked to that person, and the person will, I'll be glad to do it, and stuff like that. So they put a lot of weight on that, and that really carries the day most of the time. I mean, unless you nominate somebody that just isn't going to fare well in an evaluation or something,
Sure.
you know, other than that. So, you know, now that's why we do it, and I've never known it to not end up with the person it's supposed to be. Now,
Okay.
I've only had, I don't know, maybe half a dozen that actually had to go that route.
Yeah.
But they ended up being what they wanted. So, you know, you got documentation where you nominate the guardian, and you also give them power of attorney and power of attorney for health care, just like, you know, so they can make all the decisions for that child going forward. And so that's what we do. We know we have to end up in court, but what we do is end up in court and have this deck stacked, you know, in our favor.
So what happens if you've done nothing?
Well, if you've done nothing and you don't come home one night, I mean, the babysitter's going to, you know, if you said, hey, we're going out for date night and we're going to be back by 10:30, 11 o'clock.
Okay.
Well, it gets to be 2 o'clock in the morning and nobody's come home yet. The babysitter's going to call the police and say, hey, I'm here babysitting. There's 3 children here. They were supposed to be home at 10:30 and they haven't gotten here. It's 2 o'clock in the morning. I've called their cell phones. Nobody answers. So, you know, that's what's going to happen. That triggers a certain thing so the police will get involved in, you know, maybe some kind of accident that happens.
Sure.
And then they're going to come to the house and they'll find these children. Now, the babysitter does not have the authority to take the children. You know, they're there for the evening, right?
Right.
And so they're going to ask around if there's anybody. Well, I don't know, you know. So if you nominated anybody, you know, what we do when we nominate people is we make that perfectly clear to the babysitter that if something happens, this is who you call.
Right.
Before we call the police if there's an
Right.
accident. And so I've run this by the Pulaski Police Department a couple of years ago, the program that we do, and they were just, you know, they were thrilled with it. They said, you know, if we show up and there's a place for these children to go, it's like they're like whew, sweating, wiping their brow because they don't want to have to take these kids and put them in some kind of child protective services. Now, again, I'm not saying anything bad about child protective services. Those folks do a job, and I'm sure they do a wonderful job.
Well, it's less than ideal though. If I mean, that has to happen, and God bless those people that have to handle that. But it's more ideal if you have appointed someone or a family member that can take it.
And it's not a stranger.
It's not a stranger
I mean,
to the
you gotta
kids.
look at you don't look at this thing as the care the kids get. You almost have to look at it from the
Right.
kids' eyes.
Yeah.
And they don't understand care. They just understand that their entire world is now upside down, and they don't understand why. They don't understand how long it's going to be this way. I mean, it's just, you know, it gives you goosebumps to put yourself in that place.
Sure.
And try to imagine what it's
Yeah.
like. So, and then, you know, what happens is they go into protective service, and they, you know, the courts appoint an attorney to represent the children, or other people that come in and say, you know, other people will petition for the guardianship. And then, you know, it's a matter of proof, and
Sure.
they put on the proof as to why you're a better person than the other people that are applying.
Right,
Now, if
exactly.
there's only one person there, it doesn't mean that's the one that's going to get it. The courts still have to decide they're proper and adequate for the job.
Right.
So, I mean, if you don't do anything, it's not a good thing for the kids. And like I said, that's a thought that
Yeah.
used to wake me up in the middle of the night. You know, what's going to happen? And like I said, you never think about that when you don't have kids, but it's just those thoughts. You know, especially if they're relatively young. I mean, children rely on you for everything.
Yeah, absolutely.
You know, when my grandchildren visit, you know, they're 3.5 and 1.5. I mean, every aspect of their life. You know, when they come to visit, their parents are here, or Miss Tammy's there. Everything about their life, they rely on you to do for them.
Sure.
What to feed them, when to go to sleep. You know, if you got a cold, you're going to give them cough syrup or something. I mean, they just rely on everything. And,
Sure.
so when you think that you're the one that has to do all that, it's a sobering thought. It's like the life of this child completely depends on my decisions. And that's, you know, so if you're not going to be there, all that's taken away. And you know what the child wants, you know what the child likes, on and on. I mean, like I said, it is not ideal. It's just something that has to be done. So anyway, if you haven't done it, you ought to give it some thought. I mean, I don't talk about that at my seminars, but I do have some recorded YouTubes that talk about guardianship.
Yeah.
And the other thing I want to mention about guardianship is that when you pick people, you need to give it some thought, a lot of thought, because it's let me give you just a couple for instances is what we can deal with. Somebody might say, Stan, I want you and Tammy to be the guardian.
Yeah.
Okay? And that would be a good pick. Miss Tammy is just a super mother figure and nurturing and just that. When grandkids are around, she's just everything about her day when they're here revolves around the children.
Yeah.
They did that way when our kids were little. She's just that way. And so so they pick us. But you might want to think through. Okay, what happens? What about if something happened to Miss Tammy? Then you get me, and is that really what you wanted?
Yeah.
You know what I mean? I'm just saying, Tammy would be a great person. I might not be. I'm just saying as an example. Maybe I'm not such a good pick.
Yeah.
So when you pick a couple, you want to think that through because you might want to say, we picked Tammy, but not, or Tammy and Stan, but not the survivor. If I was okay to be a guardian, you'd say Tammy and Stan or the survivor thereof.
Yeah.
Right? But if you just want Tammy, we need to just say Tammy.
Yeah.
And you might, I can hurt my feelings, but I'm saying you don't want to hurt somebody's feelings, but you want to make sure it doesn't end up the way you don't want it.
Sure.
Like I said, a member of a couple, and I got the exact same thing. I would have no problem if my brother raised my kid, but I sure wouldn't want his wife doing it.
Yeah.
So, it's like I want this person to do it, but individually.
Right.
And so you don't, if circumstance happened to that couple, you could end up with the one you didn't want.
Yeah.
And I've seen that happen.
Yeah.
Or I've seen people that have done that, and then they went back and changed who they wanted after we had a chance to talk about it.
Oh wow. Yeah.
And the other things you want to think, just because somebody may be a little better off financially is not really a decision maker. I mean, it's something that carries some weight.
Yeah. Absolutely.
I'll give you a good answer. My brother is a dentist, or he's retired now, but I mean, he's a dentist. I mean, he did okay. And I had a sister that was probably one I would like to have kids take care of. But my sister was, she was a great person, but she's just one of those people that just kind of had several jobs in her life. And, she made enough money to get by, but not a whole lot more.
Yeah.
But she would have been a good person.
So, yeah, absolutely.
So that's who I would have wanted. So when you have somebody like that, because we homeschooled, and I wanted somebody to do that if possible.
Yeah.
And we have a strong Christian values, and I want somebody that would do that. I have a certain way. My wife and I aren't there to raise the kids, but I want the best fit for somebody like us to do.
It does require a lot of thought.
And that's why you want to think through it,
Yeah.
Do you do corporal punishment or not? All kind of things that you can think of.
Right.
And you want to find somebody to do that. Now, my sister would have been perfect for that, but she didn't have much wherewithal.
Sure.
So a responsible parent would have a life insurance policy so that if something happens and she ends up with three children to take care of, then you want her to have the wherewithal to do so.
Sure.
So in other words, you want something to at least, I'm gone, my wife is gone, I certainly would like something to stand in my financial shoes at least. And and maybe a life insurance policy that would do that, or at least pay off the mortgage of your house if you got a mortgage on it. So they have a place. You guarantee a place. It's like term life. It's cheap. Of course, if you live long enough, it just kind of goes away. But still, if that happens, that's a real deal breaker if you got a problem. If they don't have a house to live in because you're not making the mortgage payment anymore, the minor children aren't going to make the mortgage payment.
Yeah.
Somebody else is probably not going to. So you want to think that stuff through and make sure. Now, in my sister's case, it certainly would need some kind of life insurance policy for her, so she would have the money and the funds to raise these kids.
Right.
Because that's not cheap, as you know.
That's right. You're right about
So
that.
there's, and again, there's like a hierarchy of how you pick people, and you can just go through it. Because, one thing when you nominate guardians, you nominate people you want to take over your children, but you can also identify people that you absolutely, positively want to exclude. And that carries a lot of weight.
Oh, wow.
You can say, hey, I want, it's okay if my brother or my sister do it, but absolutely positively don't want my youngest sister to do it.
Yeah.
You know what I mean? And that carries a lot of weight with the court because it's your express wishes during life while you were soundness of mind thinking this process through.
Does that operate similar, I guess, is that part of the will or is that a separate document?
Oh, it's a separate document.
Okay.
They're just guardianship forms we fill out. They're not even official forms. It's just a document that we create. And, you know, it's, you do it and it's witnessed and notarized, so it has, you know, pretty strong dignity that it was you that did it.
Okay.
And that's something, when you get to court for this guardianship order, you present it to the court as
Yeah.
proof that they did nominate people
Yeah.
during life.
Well, we got a caller calling. Now let's see if we can get him on here. Hey, good morning. How are you?
I'm good, good. I know you guys have been talking about the guardianship thing, and I guess this might even be a kind of a 180, but
That's all right. That's all right.
I'm concerned about my situation. Basically, it's just my wife and myself. We don't have any children. Whenever we're gone, what we have, you know, I've got two sisters, but they're older than I. So, you know, but you don't know the certainty. But just you know, you know, where would our estate go if both of us are gone? And I know it would go to the next of kin, I guess, or, you know, and what would be the best situation as far as naming someone for that, you know, whenever we're gone, or would it be a good situation to go ahead and get something in place? And I know it would be, as far as getting somebody named to take care of our estate, or to take, you know, and could we put a clause in there that, you know, that they would provide care for us, or be a someone that could make decisions for us if we're not able to make them ourselves. So
Yeah, those are good questions.
all that being said, I'll hang up and listen.
All right. All right. Thank you, buddy. Yeah, those are good questions.
Yeah, he said it was a 180, and it's probably a good time. I was about to wrap up the guardianship anyway, so we can just shift gears and go into that. And,
Yeah.
And it was a pretty all-encompassing question. No, if I, you know, he kind of faded out there a couple times, and he was trying to talk, but it wasn't coming across.
Yeah.
But I think I can piece it together.
Yeah.
And so he, you know, it's him and his wife. They don't have any children, but they have possessions. They have stuff. They call it your stuff.
Yeah.
And, you know, what would happen to his estate? He said, me and
Right.
my stuff. And then another question that's a little different about, you know, how you go about naming people that help make decisions for you.
Yes.
Okay, so as far as the estate goes, I mean, and the answer, when you say, where's my stuff going to go if we pass away, the answer is, and I don't want this to sound flippant, but the answer is it's whatever you say is going to go. And when you say where it goes, you have to say so in some enforceable instrument, like a will or a trust. If you do a will, you say in the will, my stuff goes to, and you name people. And you can even be specific, like this, my car goes here, and the house goes here, and the money in the bank goes here. Or you can just say, you know, everything I have goes to my two sisters that you mentioned. You know, you can dictate where it goes, but you have to do so in an instrument, in a testamentary instrument like a will or a trust. Okay.
Yeah.
Now, I think the question was a little geared more toward if you didn't do anything like that, if you just never got around to doing a will or a trust, then what happens?
Yeah.
Then what happens is the state of Tennessee writes a will for you, like I always say.
Yeah.
And God bless them, they've already done it.
Yeah.
What they will do is, it's called the laws of intestate succession. And they will decide where the property goes if you didn't write a will. Now, if you write a will, that's what they'll honor.
Right.
Or a trust, that's what they'll honor.
Right.
Now, if you have a trust, you don't ever end up in court. So, but that's how it gets done if you've already said where it goes. But if you don't, they go to the laws of intestate succession. And here's the hierarchy of how they start looking for where to put the property. If you're married, the first place they'll look to see is if you have a surviving spouse. Now, the surviving spouse doesn't get all of it, but they'll look to see if you have one. If the answer is yes, or if the answer is no, then the next place they go is, do you have any children?
Yeah.
Okay, so let's kind of play it out. I guess in his case, it didn't have any children, so I'll just stick with the example. In his case, he didn't have any children, but let's say if he passed away, but his spouse was still alive, then everything would go to the spouse.
Yes.
Okay, now, if he had children, it would be divided between the spouse and the children.
Yeah.
The spouse would get a third or up to a child share, and the children would all share the other 2/3.
Yeah.
Now, If he was the second death of the couple, meaning they look to see if you have a surviving spouse and she had already predeceased, now it's going to, again, look to see if there's any children, and the answer in his case is going to be no. Then it's going to look up to see if any parents of his parents are available, and usually that's a no. Then it's going to start looking sideways to siblings. Oh, he's got 2 sisters. Now it'll come to them. Now, if those sisters predeceased, it'll start down their bloodline. If they have, that would be nieces and nephews, right?
Yeah.
And it goes on from there. There's a hierarchy of how we look for somebody.
Right.
Now, and usually you can find somebody.
Right.
But if the situation turns out that they cannot find any place for it to go, I mean, they look, they follow the chain, you get to the end of the chain, there's just nothing there. Everybody either didn't exist in the first place or have predeceased, right?
Sure.
And because like if he doesn't have any children, there's never going to be anything down that line because there's no
Right.
children to begin with. Then it will do what is called escheat to the state of Tennessee, and that's what happens to property. So it's always a good idea to have some instrument. He even made the comment, he said, I know, he said, would it be better to have something? He said, I know it would be.
Yes.
And you're right, you hit the nail right on the head.
Right.
I mean, let me put it this way, it would be better to have something if you want to make sure your stuff goes where you want it to go to.
Right.
Now, if you say, I don't care where it goes, they can just fight over it. Well, then don't do anything. I mean, because it doesn't matter to you. If you want people that do this, it matters to them where their stuff
Right.
goes. So, and most people do.
Right.
So then if you say, okay, the laws of intestate succession is not really the way I would want it to go. So now to make a difference and make sure it goes a different way,
Right.
we have to memorialize that. And we have to do it in a testamentary instrument like a last will and testament, or we can do it now during life in a living trust.
Right.
And that can dictate where people go. Where property goes. Now, the second part of the question, I mean, do you think I answered that?
Oh, yeah, absolutely.
Okay.
I think we're good.
I want to make sure the question gets answered. The second half of the question was, suppose I'm not able to make my decisions.
Yeah.
Now we're talking about power of attorney.
Mm-hmm.
And power of attorney is something that does not survive death. I mean, it happens during life. We call it incapacity planning, your powers of attorney.
Right.
That's when you don't have the cognitive ability to make decisions for yourself, either health decisions or any other decisions.
Right.
Or what people call the other one financial, because there's actually 2 powers of attorney. There's one for healthcare and healthcare only, and then there's one for everything else, which is called the general durable power of attorney, or people say the financial one.
Right.
And it's more than finances, it's just everything other than health. And so this is incapacity planning. So if you can't make decisions on your own, what you want is a trusted loved one to make them for you.
Yes.
Okay? You don't need the court appointing somebody to step in and take care of things for you because they don't know you, they don't know your morals, they don't know your values, they don't know what you ever wanted or how you lived your life. They'll just step in and do whatever they think is right, and they don't have any guidance. So you want
Right.
somebody, and most people name their spouse first,
Right.
maybe an adult child, and you want to have this down there and give them all the powers that they need, because you have to give this power to them.
Right.
Just because you're a spouse, you don't get it. I get
Okay.
that complaint all the time.
Oh, really?
People try to do something financially. When you live in a small town like we do, Pulaski and Lawrenceburg,
Right.
it seems like you can get away with a lot. But when you start dealing with banks that are everywhere,
Right.
you know what I mean, like Bank of America or Wells Fargo or something like that.
Right.
I mean, they don't let you do that. So if say a wife goes in to do something for her husband,
Yeah.
the husband's incapacitated.
Yeah.
He didn't do a power of attorney.
Yep.
And she's trying to do something, they can say, no, we can't do it. You don't have the authority to do it. We need a power of attorney before we can even talk to you.
Yeah.
And it's like, well, what do you mean? But we've been married for 55 years and stuff like that. He said, well,
Right.
that is not, right, wrong, or indifferent. I'm not arguing that. Right, wrong, or indifferent, it's not enough.
Yeah.
You have to have this power of attorney. Now, the person that gives you the power of attorney has to be of sound mind before they can give it. Just like anything else in the legal world, if you're going to sign a document or pursue something, you have to be of sound mind to do it. You got to know what you're doing.
Right.
And so those are very simple documents put together, power of attorney, and they go together. The other one's for healthcare, which is your quality of life and the resuscitative measures. If
Sure.
if you're in any of these unacceptable qualities of life, it's called the Tennessee Advanced Care Directive.
Right.
You can also do something like a living will, where you can put down some other things that if you're
Right.
not able to make your own health decisions, you can say, well, this is my diet, you know, I'm a vegan, so, you know,
Yeah.
I'm gluten-free, or,
Right.
you know, don't give me any pork, you know, whatever, you can do stuff like that, or, comfort things that you would want somebody to do because you're not able to do it for yourself.
Right.
And, so I advise, and you've heard me talk about power of attorneys before, I mean, I have a pet peeve on power of attorneys, everybody needs one of those at any age, because I'm telling you, stuff happens. And
Yeah.
I could write a book. It's not just when you get old and can't make your own decisions. Suppose you're on I use an actual situation from not too long ago. Suppose
Yeah.
you're on a motorcycle and you wreck it and you end up with some brain trauma.
Oh, yeah.
And now you have a young wife at home with young children, and you can't make decisions. And you don't have a power of attorney.
Right.
She is in a bind. Now, the problem is, if you want to make a power of attorney and you're of sound mind, like you and I are,
Yeah, we hope.
yeah, you can just come in and sign the document. That's a done deal. You know,
Yeah.
then you've done it.
Yeah.
Now, if anything ever happens, the person that wants to act for you, their authority to act resides in that very document. So you go to the bank and say, I want to deal with this bank account for my husband. And they say, well, under what authority are you dealing with your husband's bank account?
Right.
And the answer is, here's my authority right here, power of attorney granted to me. And of course,
Right.
when we write the power of attorney, it conveys and refers to the statutes.
Yeah.
And in my power of attorneys, we actually list the actual power. So it's a relatively longer document. And we do that for a specific reason. But here's my authority. The bank
Yeah.
will recognize that immediately.
Yeah.
You know, now, if you do have this motorcycle accident and you don't have a power of attorney, the wife can't act. Now we got a problem because you're not of sound. You don't have the cognitive soundness of mind to give the power to somebody. It's too late.
Yes.
You have to give it to them when you can.
Right.
Not once you become incapacitated. Now there's only one legal remedy alone, and that is to go to court and get a conservatorship.
Yes.
I mean, everybody's heard the term conservatorship, right? Good way to think of what a conservatorship is it is a court-ordered power of attorney.
Right.
So the only person that can involuntarily give somebody a power of attorney is the court. Okay, and you got to go through it. Now it's a pretty long process, and I'll tell you something else. It's pretty expensive.
Yeah.
I mean, when we do documents for power of attorney, they're relatively inexpensive. You know, a couple $100 or something like that. Very, very inexpensive. When you do conservatorship, I mean, I've seen it range anywhere from $7,000 or $8,000 bill to 10 or 12.
Really?
It just depends on on certain circumstances, but it's way, way expensive. It's so much easier to do this now and take care of it. And it takes every bit of, I don't know, 3 or 4 to 6 months to get to the end of the road where you finally get what's called letters of conservatorship, and that's now your court-ordered power to make these decisions for the
Okay.
person.
We got someone else that wants to ask us about what we're talking about here. Hey, good morning. You're on WDXE with us.
Good morning, Jeff. On this power of attorney, like if you're appointed, does it have to be registered, or I mean, do you have to have it through a court or something like that, or can it just be wrote on a piece of paper, or has it got to be documented?
It's a good question.
Yeah, okay, I got an answer.
We'll answer that, okay?
Okay.
Thank you, buddy. Yeah.
Yeah, good question. What he's asking is, if you do a power of attorney, what is the dignity of it as far as a legal document?
Right.
And this will surprise you. So I kind of
It's gonna surprise me.
It's going to surprise the caller and everybody else is listening.
Okay.
And because it surprised me. And when you do a power of attorney, now I'm talking about the financial power of attorney.
Yes.
All it needs, according to our statutes, is your signature.
Really?
Now, I had something came up and we thought, surely it has to be at least notarized or witnessed. So I went looking. I read the statutes. I read through all of them. I come back and read them all again. It's not there. It needs to be signed, and that's it. It does not need to be notarized, does not need to be witnessed. Now, that being said, I always either notarize, witness, or both when I do it in a trust plan, and here's why. When you get to the bank, if it doesn't have some kind of dignity on it, they balk. Now, you can sit there and try and explain to them the law and the statute says it doesn't have to be, but you know what, it's not a fight worth picking. So when we're doing our trust plans and people are there and I got my notary and my witnesses, we notarize it and witness it just, even though it doesn't need it. I hate doing things I don't have to do, but it just saves an argument somewhere down the road. So we do it, but surprisingly, it just requires a signature. I mean, if you want to go read those statutes, go read them. You won't find it. It's not there.
Yeah.
It's just signed by the.
But now,
it's signed by the principal. That's you.
I guess I would ask a question about that. If I just sat down at my desk and typed one out myself and signed it myself and gave my wife power of attorney, I guess legal, it's okay according to statutes, but it's gonna meet opposition
I
when you
think
go
you're
to
gonna,
use it.
I think it's gonna be problematic.
It's
because-
gonna meet opposition when we use it.
I
So you
think
want the credibility of
Yeah,
it.
the people you show it to are not gonna understand that. They're gonna say, well, how do I know you signed it?
Yeah.
Or if she comes in, cause you're incapacitated, right?
Yeah.
They can say, well, you know, but it doesn't have to be. So that's something the law, I think, should fill in the gaps, cause other states require stuff. Now, contrast that with the healthcare power of attorney, the Tennessee Advanced Care Directive. If you get that thing, right on the front of it, there's gonna be a box, and inside the box is gonna be a little paragraph. The paragraph is gonna say, this can be either witnessed or notarized. Doesn't need both, one or the other. However, it goes on to say that if you witness it, it can't be interested witnesses. In other words, it can't be people that take under the estate.
Right.
So if you do a power of attorney for healthcare, you don't have your kids witness it.
Right.
I mean, you gotta get an independent and uninterested witness. So people that don't have a dog in the fight, right?
Right.
That's what it requires. Or just get it notarized, that's enough.
Yes.
So.
So it's always better to have it done.
That power of attorney requires a certain amount of dignity. You know,
Yeah.
we call it the dignities document. You know, that requires at least notary or witnessing. So
Yeah.
something else to prove that you were the one
Yeah.
that did it, where the general journal does not. Now, I would never not do it that way.
Yeah.
Because I just, there's a matter of legal fact and a matter of practical legal fact. You know,
Yeah.
in reality, it only needs to be signed, but in practicality, it's gonna have a problem.
This has been a little while back, but a friend of mine passed away suddenly, way back, and he had a business, and his wife had to take over everything, but she wasn't on any of the business documents and did not have this power of attorney, and the banks shut the account down, and she couldn't get in. But she had to get a lawyer to help her get the bank accounts.
She would have to go after this conservatorship.
And had to go through a whole process to get it done, and it was really a painful deal to make all that work.
And they were probably married for a long time.
Oh yeah.
Now
Yeah.
listen, if you're a married couple, you're married for a long time, don't get mad at me when I say that's not enough to just take over somebody's business and their financial affairs.
Yeah, you would think it would be.
It should be, I agree.
You would think it would be, but it's not. The
But
banks won't look at it that way.
It is not. No, not in this state.
Uh-uh.
Power of attorney is governed by if most states are the Uniform Durable Power of Attorney states, Act states, but it's not the power you need. Now, like I said, a lot of people say, well, that's not true because so-and-so became incapacitated. I went to the bank and they let me write a check. I mean, when you're in small towns and and you know the people, I see that happen. A little less adherence to the rules. But from a legal standpoint, it's not enough power to do that.
Yeah.
But again, if you get into something now, we do a lot of that 10-care stuff we talk about. You get into that arena, you're going nowhere without a power of attorney. That's one of the first things we have to do if somebody doesn't have one.
Yeah.
Somebody comes to me and says, hey, my wife's in a nursing home. I'll say, do you have power of attorney? You say, no, we don't have anything. The next question is going to be, is your wife able to sign one? Because we need one for just about everything we're about to do.
Yeah.
And if they say yes, well, then we set it up and have her sign it. But if they say no, I mean, we got to go to this conservatorship to be able to act for that person. And that's, that gets pretty involved.
Had some good phone calls this morning.
That was a good question.
766-9393. If you want to talk to Stan this morning or got questions concerning estate planning, wills, trust, all that stuff.
And I remember when I was looking through the power of attorney for the dignity, I remember giving it to my assistant Alex and said, I want you to read through this. Just see if you come to the same conclusion, because in case I missed it. I'm pretty shocked it's not there.
It is amazing.
Yeah, but it's not. I mean, that's a challenge I'll throw there. If you can find out where I missed it, let me know. But I'm pretty sure I didn't.
But when you go to use it,
that's the problem.
When you go to use it, whatever entity you're using it with, they're going to want some credibility with that thing.
Now, speaking of the what we call the dignity, right?
Yeah.
Now, let's talk about the dignity, because I think people get confused about that. Some people come in and say, hey, I got Daddy's will here. He wrote it out and had it notarized and everything. That's an invalid will. It doesn't need to be notarized. It needs to be witnessed.
Okay.
Now, what's the big difference between witnessing and notary? I mean, there is a difference.
There is a difference.
A notary is a person sometimes it's called a verification.
Yeah.
What the notary does, the notary has no interest in the document.
Right.
If you go to a notary and they start reading the document, you might say, listen, I'm not asking you to read it. I'm not asking you to approve it. I'm just asking you to notarize it. What the notary does is they verify that you are the person you claim you are, and the person that's signing the document. So a lot of times if you go to a notary that you don't use, like you're someplace, they'll ask you to produce driver's license and ID. And then they'll look at the document as far as the name under the signature and who's signing this thing. And if they're satisfied that it's you, then they notarize the signature. I mean, they have no concern or input on the document.
Right.
And a lot of times the notary clause will say, you know, to whom I'm familiar with, or who's satisfactorily proved that that's who they are. So, you know, if I'm a notary and you walk in and ask me to notarize something, I'm not going to ask for your ID. I know you. I know you're Jeff Hood. Document is supposed to be signed by Jeff Hood. I'm going to go ahead and notarize it.
Yeah.
That's okay, because I'm already personally acquainted with you.
Right.
But if somebody else walks in, or somebody shady like LB comes in and I work, I hope he's not listening. No, but if somebody else walks in and you're a notary and you don't know them, see, I got two notaries in my office, and every once in a while people walk in and say, "Do you have a notary here? I need to get this notarized." Right across from the courthouse.
Right.
And you know, Alex and Tammy are both notaries. If they don't know them, they'll just ask for a driver's license, some form of ID, and then they'll sign. Now that's verifying that you are the person you say you are that's signing the document. Okay. Now the witnessing is something different.
Yeah.
The witnesses are actually there and they're signing it, and the witnesses are purporting that you are of sound mind when you did it. So certain questions can be asked.
Yes.
Now again, not entirely sure they have any concern with the actual document, but it's like if it's a legal document and it requires sound mind, they're signing and say, hey, the person appeared to me. Now they're not doctors, so it's not the end all be all. But the person appeared to be of sound mind and disposing memory.
So the witness is witnessing the fact that they're signing this document and mean what's in the document.
That's right. Now, they are also, when you witness it, they also have to be satisfied that that's the person that they say they are.
Right.
And they have to, the witness has to literally see you sign the document. And so does the notary. When you sign a document, it must be in the presence of a notary. And when you witness it, the signature must be in the presence of the witnesses. It's even more so with a will. I mean, they go beyond in the will and they say it's got to be within the sight and the presence of the witnesses.
Right.
And what does that mean? Think about it. If you're
Say that again now.
Okay, when you do a will, the statute says it has to be witnessed by two witnesses, and the witnesses and the testator, the person making the will, have to witness the signature of the testator and be in both the sight and presence of the testator when he signs. And it also says the witnesses also have to be in the sight and presence of each other and the testator when they sign.
Yeah.
So perfect answer is we're sitting around my conference table, both witnesses there and the testator's there, you know, and I announce the fact that, okay, you're the testator and you're going to be signing this in the sight and presence of these two witnesses. Here, Joe and Susan are the witnesses.
Yeah.
And he says, yes. I says, and the witnesses are going to be signing it, and they're in the sight and presence of both you, the testator, and each other.
Oh yeah, that's right.
Now,
That's right.
what does sight and presence mean? Well, let's try a couple of examples. You're sitting in my office, we're around this big conference table, we're all there, we're all in sight and presence. Suppose one of the witnesses is standing on the steps of the courthouse, which if you look out the window of my conference room, you can see the steps of the courthouse, so you can see the person standing there. Now, they're in sight, right?
Yeah.
But not in presence, because they're not going to hear it. Okay?
I got you.
Now, suppose, let's try the other way around. Let's say you got one witness is in the next office,
Yes.
in Miss Tammy's office. The walls, doors closed. I mean, they're not in sight, but they could be in the presence, right?
That's
You know,
interesting.
or if, so, you know, and here's it starts to get ridiculous when you talk about that.
Yeah.
Here's why we go to such length to be ridiculous, because the statute in Tennessee, the courts have said over and over again, I mean, it's a long precedent, that they will construe the validity of a will with strict compliance.
Yeah.
When I say strict compliance, there's nothing that's good enough. If it's not, in other words, it says in the statute that at the signing, the testator, the person writing the will, has to purport in the sight and presence of the witnesses that this is his will. He
Yes.
has to also purport that he's of sound mind and disposing memory. Now what that means is he's got to say it,
Yes.
not sign something. He's got to say it. And so we sit here, and you know, I get a lot of flack sometimes when we do these wills because people roll their eyes like, well, this is silly. But if I don't do it, it's fatal to the will. So I think I've talked about this before, but let me just go over it again. We're sitting at my conference table. The two witnesses are here to my right, and the testator to my left.
Yes.
And I'll say, here's what I'll say. I'll say, all right, you are this. I'll say this is a formally executed document. That's what you call a last will and testament.
Yes.
It's a formally executed document. Now I've got to go through the formalities. I have to answer you I ask you a few questions. You have to answer them out loud, and I'm going to, in sight and presence of everybody here.
Right.
So I say, okay, you are John Doe, and you are purporting that this is your last will and testament. Is that correct?
Yes.
You'll say yes. And I'll say you are purporting this to be your last will and testament, and you are doing so in the sight and the presence of the two witnesses, which over here is a Bob and Sue.
Yeah.
And they say yes. I say, okay, you're also purporting in the sight and presence of these two witnesses that you have sound mind and disposing memory. And what that means is you know and understand your property, you understand the fiduciary relationship of the people we're naming in these documents, and you understand that this is a plan that will distribute property after death.
Yes.
So the question to you is, do you understand what you are doing? You'll say yes. And then I'll say, and you're going to be signing this document in the sight and presence of these two witnesses? Yes. Okay. Now the two witnesses are also going to be signing the last will and testament, both in the sight and presence of you, the testator, as well as each other. And it's like, okay, now we can sign.
Yeah.
People roll their eyes, and my witnesses and notary have heard it a bazillion times, right?
Yeah.
But they roll their eyes and say, that's pretty silly and stuff. So, well, you know what? If somebody can prove I didn't say that,
Yeah.
it's about, the will's not valid.
Yeah.
And
I've actually witnessed a will and had to sit through exactly that with an attorney who evidently knew what he was doing.
I mean, you read through the court cases.
Yeah.
You got somebody that witnesses it, and somebody comes in 2 hours later and looks and says, "Yeah, that's Jeff Hood's signature," and they witness it. Not good enough. That's failed. It's a failed will, and the court says strict compliance. If there's anything wrong with it at all, the will's invalid. I'm going to give you a good example of a court case.
Okay.
It was a will. It was a pretty comprehensive will because it was a estate that had a fair amount of stuff in it. Okay, so it was no back of the envelope kind of thing, somebody just scratching out.
Right.
It was done with an attorney's office. And I mean, this, I sure would have hated to be this attorney when you hear the end of the story. But anyway, you get to the end of the will, and there's a signature line underneath it that says John Doe, which is the testator. He's supposed to sign it, right?
Yeah.
And his signature was not on that line. Now, you turn the page, and the thing after a will, that should be after every will, but it's not really part of the will, is what's called a self-proving affidavit.
Yeah.
Now, I often tell people a will does not need to be notarized. It needs to be witnessed. There is something that needs to be notarized when you do a will, and that is the self-proving affidavit of the witness's signature. Now, when you read the self-proving affidavit, both witnesses sign it, and that's notarized. And the affidavit says, pretty much it says on there, I swear that the attorney said what he said, and we did what the attorney just said. All those things, the person was here, they were in sight and presence, they signed the will, all that stuff. And we do that so that if we have to prove the will and bring the witnesses in to prove the will, and one of them has passed away, we subpoena in the answer to the 5 questions they're going to ask them if they were alive to bring into court and ask.
Sure.
Because that's what we're going to ask. What happened around the table? Did you do all this? Did they purport it to be their last will and testament? Did they sign it? And all those 5 things. And you've already answered the questions with the self-proving affidavit. So to prove the will, they just got to bring in the affidavit.
Yeah.
Now, this case, at the bottom of the will was his set line and his name under it, no signature. But when you turn the page and went to self-proving affidavit, there was a line for both witnesses and a line for the testator, which I never put on a self-proving affidavit because he's not affirming anything. But his signature was there. And you read the court case, and you could just feel the court trying to make this work. Like a tear was in their eye, like saying, I'm just trying to do anything to make this work. But what happened is they said, and they go to the statute, and the statute says the testator must sign the instrument. And they said, when they look at this, self-proving affidavit was not the same document. I mean, they were trying to make it work, and they couldn't because it clearly says self-proving affidavit. The will says page 1 of 15, and the last page of sign says page 15 of 15, no signature. You go to the affidavit afterward, it doesn't have a page number on it because there's only 1 page.
Right.
And they came to the conclusion and said, it fails because the testator did not sign the instrument. They said, but he signed the very next page, and there it is, in black and white. Invalid will.
Wow.
And this was a decent will in a decent estate.
Wow.
Now, that poor lawyer, I don't know.
We'll take another call?
Sure.
All right, let's take another call.
We got 6 minutes, so.
Hey, you're on the air with us.
Talking about a will, where is a good place to store a will or a power of attorney if you make one? And how does your people know, like if you die, how do they know that you've got a will or a power of attorney, and how do they know to where to go to look for it? Like if a person goes to the bank to try to get get your money after you buy, they've got to have those papers in hand.
Right. I'll tell you what,
I can answer that.
we'll hang up with you and you listen, he'll answer, okay? Very good.
Yeah, good question. Here's what I tell people when you're doing a trust plan or a will plan in my office. I always say, listen, you got this plan, what you need to do is tell your people you have a trust plan and where it is. So it's like this, hey everybody, I did a trust plan, it's under the bed. And
Yeah.
I say the reason you tell them where it is just like the caller said, if they need to act on your behalf, their authority resides in those documents.
Yes.
Now I often say, you don't have to tell them what's in the document, that's a private document. I mean, you can tell them if you want, but you don't have to. But
Right.
they need to know where it is. And I say, but you know, if you want to put in a gun safe at the house, or a fire safe, or a lockbox at the bank, you can do that, but make sure they know how to get into it.
Yeah, somebody needs to know where it is and have access.
That's right, and because she's right, you do need those documents, especially the will. You always need the original will.
Yeah.
And so it doesn't, now, a will doesn't get recorded anywhere until you open a probate estate.
Yeah.
But what you can do, there's a statute that says if you want to take it to your clerk and master's office, you know, and they will store it in their big safe.
Yeah.
Now, I've talked to the clerk and master over in Giles County in Crystal Green one time, I brought that up, and she goes, you know, I saw that statute. I said, anybody ever asked you to do that? She goes, no. You know, I've been here for 20-some years. She goes,
Nobody's ever
asked me to store it in the safe. But that exists.
But you know, some people may take it to their bank safety deposit box.
Yes, but
okay?
same
But if
thing.
they do and nobody else has access to it, they're in trouble.
Still well, we can get in there, but let somebody know how to get in your bank. You're safe to get at it.
Yeah.
Like I said, tell them you have it, where it is.
Yeah.
That's the answer to that question. I mean, they should know. You can keep secret. Say, I don't want to tell them what they're getting in the will. You don't have to.
Yeah.
Just tell them you have a will,
Yeah.
and here it is. It's under the bed. If you know, so we go get it or wherever it is. You
Right.
have the ability to go get it because if they need to act on your behalf, like an incapacity,
Very good.
their authority resides in that document. And so
Very good.
then you can get it. So, yeah, if you do it all in secret, it might be just a big old scavenger hunt. People say, I don't know if you had a will or not. We tore the house apart, couldn't find one.
Yeah.
That's not the best situation. Let people know you have one.
Yep. Let them know where it is and how to get it.
And tell them if you don't want to know, say you'll find out in the due course of time. I mean, you can do that. I have some people say, I don't want my kids to know what's in it till I'm gone.
Yeah.
And okay, that's great. It's your document. You can do that. Some people say, no, I'm going to give a whole copy to my son because he's the successor trustee or the executor. I'll let him have a copy of it, and they can see it. And that's okay too. It's up to you. It's as public as you want to make it. It's a private document, but it's as public as you want to
Right.
make it. If you want to show people what's in it,
Yeah.
you can. But no, you don't need to.
Well, Stan, tell them how to get in touch with you and where you are.
Gosh, we are running out of time. Yeah, Pierchoski Estate Law, right on the southeast corner of the square in Pulaski, right next to the Star Theater. You can't miss me. Telephone number is 931-363-7222, 931-363-7222. You can go to my website, which is Pierchoski Estate Law, but if you want to get there a little easier, just type in estateplanstan.com, and that'll get you there. You can call me or ask me a question by email, or you can see my calendar and see where I'm going to be, at least publicly. And I'm going to be, the next public seminar I do is right here at WLX radio station in the back at what you call a country cafe, which is not really a cafe.
Right.
At September the 20th, it's a Saturday at 10 o'clock that morning, Will's Trust in the Nursing Home. If you haven't been to one, I think you'll really enjoy it because I get tremendous reviews on the amount of information,
Sure.
the quality of the information. It opens up people's eyes to hear about options they never knew before. It is truly educational. I call it free educational seminar. I focus on the word educational. I mean, it is free. I mean, you show up, you can, the no obligation kind of thing, show up, we'll have some light refreshments, and you'll learn a lot. It's great. I enjoy doing it.
Well, I've certainly learned a lot, and we had some good calls today, some good instruction there for planning and the importance of planning. The power of attorney thing is very interesting and
Very important.
very important for both your well-being all around and your care for, if you're incapacitated. I mean, people don't think about that.
I mean, if you got to go to conservatorship for some of your family, it's a nightmare.
Yeah. Stan Pierchoski, everybody. Pierchoski Estate Law in Pulaski, Tennessee, there on the square. Not hard to find at all. Look him up online at estateplanstan.com. And of course, make plans to go to that next seminar.
We'll be back next week.
Next Friday, buddy, we'll be back. Good to see you.
For the next episode of Bulletproof Estate Planning.
See you next time.
Okay, bye.
WDXE 237 FD Lawrenceburg, broadcast